morning, ladies and gentlemen of the jury. Thank you for your patience and continued engagement with this trial, especially as it reaches its ending stages. In my closing remarks, I would like to bring you back to my opening statement when I asked you to think about that phrase, "What doesn't kill you makes you stronger," and how in Miss Winther's case, that phrase was extremely wrong. Although she survived the encounter with the defendant, it did not strengthen her. It left her permanently and severely weakened, both physically and mentally, because of the pain that she suffers on a daily basis. Throughout this trial, you've heard testimony from experts, doctors, as well as Miss Winther herself, about the extent of the foot, ankle, and low back injuries that she has sustained from being hit by the defendant's car on July 3rd, 2017. Now, as you begin to deliberate, I understand that it would be complicated to somehow apply everything that you know about Miss Winther's injuries to this form that you're going to be given, and how to use that information to answer each question on the form. So in my closing remarks, I'm going to walk you through the form, and I'm going to connect each question specifically to the evidence that you've heard in this trial, so that you may come to a clearer conclusion and be sure about your conclusion. Before I do that, I would like to establish that the defendant was negligent. In my opening statement, I told you that drivers have a heightened duty of care, especially when they're driving in pedestrian-heavy locations like store parking lots. And the number one rule of that duty of care is to be aware of your surroundings. You all heard Miss Winther's testimony. When she described the moment of impact, she looked at the windshield where the driver's face should have been, and she saw not that the defendant was looking up, she saw that she was looking down. And to be aware of her surroundings as a driver, the defendant needed to either be looking up and through the windshield or out one of the side windows. And any reasonable driver, had they been paying attention to their surroundings, would have seen Miss Winther crossing the crosswalk in time to stop. So that means that the defendant was not being aware of her surroundings, she did not uphold her responsibilities as a driver, and was therefore negligent. But the verdict form does not ask you whether the defendant was negligent. The first question on the verdict form asks, was the negligence on the part of the defendant a legal cause of the plaintiff's loss or injury? Now, you've heard a lot about how Miss Winther's life was before this crash. She was an active marathon runner, she trained consistently, she was a nurse who would work 12-hour shifts without any problems. And although she's still a nurse, she testified to you that some days it's hard to be on her feet for that long. And some days she needs to drop out of a race, or she cannot train as much as she would like to. The level of physical strength that she used to strive for is now unattainable. And Ms. Winther's doctors confirmed all of that testimony. You heard from Dr. Duane McRory, who confirmed that Ms. Winther suffered an acute soft tissue trauma from the tire rolling over her ankle. As a result, she experiences intermittent swelling, pain, stiffness in the ankle, and she has difficulty flexing her foot upwards, which affects her ability to run and walk. You also heard from Dr. Brett McDermott, Ms. Winther's physical therapist, who attested to the fact that she never complained of radiating back pain before July 3rd, 2017. And he found her complaints after the crash to be so alarming that he ordered MRIs of her lumbar spine. You also heard from Dr. Mark Brodsky, the orthopedist that reviewed those MRIs. He confirmed that the cause of that radiating pain, of her radiculopathy, was most likely those disc bulges and disc herniations that she had throughout her low back. Now, the defense will have you believe that there is no correlation between these injuries and the accident. Their experts, however, although they have different conclusions from us, their methodology seems to go along with Ms. Winther's story. For example, Dr. Paul Maluso, the defense's expert, agreed with Dr. Shido Hub's EMG findings that Miss Winther could be experiencing, he agreed with the EMG findings to the extent that overstimulation of the L4, L5 nerve could result in loss of sensation in the foot. However, he disagreed with Dr. Scheidel-Hub insofar as that was the case with Miss Winther. He said, this could happen in some cases, but it is not happening with Miss Winther. And when asked why that was, he simply said, based on review of the MRI of her foot, I could not conclusively determine that that kind of nerve trauma was occurring, that kind of nerve stimulation was occurring. I'll remind you what I said about MRIs in my opening statement. They're typically used to diagnose trauma to soft tissue and bone. They are not the principal resource to determine whether nerve damage has occurred. So Dr. Maluso's conclusion is both contradictory and scientifically insignificant because of the way that he arrived at it. You also heard from the defense's expert, Dr. George Stanley, who concluded that Miss Winther could not have possibly experienced a back injury in this crash because she had a pre-existing disc bulge. But Dr. Stanley turned around and said that a disc bulge that was previously asymptomatic could turn into a full-blown disc herniation and cause pain after an acutely traumatic event, like getting hit by a car. So both of the defense's experts, although they say they do not agree with Miss Winther's medical practitioners, don't seem to have any reasoning behind their differing conclusions. And you might ask yourself, why? Why are they disagreeing? Well, I can tell you why. The defense pays them a lot of money to come up with these reports and to testify about them. They make careers out of it. So they have to say this. So, in consideration of the first question, think about Miss Winther's quality of life before and after the crash, and also think about the relative credibility of the doctors who treated her one-on-one in person for years before and after the crash versus those doctors that, based off of some light review of some of her medical records and motivated by money, created these reports differing those conclusions. And if you find that it is likely that the accident caused Miss Winther's injuries, go ahead and click yes for question number 1. Now, for question number 2, we get into the costs of medical expenses. The question asks, what is the total amount of plaintiff's damages for medical expenses as a result of the July 3rd crash? And it's divided between medical expenses in the past and medical expenses in the future. Medical expenses in the past is pretty straightforward. You have the bills, you have the records, you've heard the testimony about the chiropractic adjustments, the physical therapy, the steroid injections, the acupuncture treatments, the MRIs, the x-rays. It's all been very expensive. And both sides have stipulated that Miss Winther's past medical expenses come to $59,607.78. That's in the evidence, cut and dry. When it comes to future medical expenses, I have 2 proposed amounts. There is a very conservative amount that has also been stipulated by both sides. It is based off of Dr. McDermott's testimony that Miss Winther has likely reached maximum medical improvement, meaning the way she is now is as good as she's going to get. The pain radiating from her low back into her hip and her glute and down her leg, the loss of sensation in her foot, the tingling in her leg and her foot, all of that is here to stay. The best that she can hope for is to pursue physical therapy and chiropractic adjustments and to maintain a minimum level of comfort. And then there's also the testimony of Dr. Mark Brodsky, who says that she's very likely to need back surgery at some point in the future. Based off of all of that evidence, both sides have stipulated to the very low amount that she will need $346,826 for future medical care. However, you also have in your possession a future care report, which has been prepared by a team of statisticians and actuaries, very intelligent, objective third parties, who, based off of her past medical treatment and ongoing medical conditions, as well as her life expectancy, have reached another amount, which is $552,534.97, to cover the medical expenses that Miss Winther will need throughout the next 19.8 years of life. Finally, we come to question 3 on the verdict form, which is the most complex. This question asks, what is the total amount of plaintiff's damages for pain and suffering and for loss of enjoyment of life sustained as a result of the crash? And this question too divides the figure up into pain and suffering of the past and pain and suffering of the future. This is a very difficult question to quantify because when we talk about pain and suffering, we're talking about the mental anguish that's caused by every day, every hour of living in this radiating pain. This is talking about the horrible feeling of missing out by having to sideline herself from her family's most important events, or having to drop out of a race, not being able to walk or to run as well as she used to. Miss Winther was a very active, healthy individual before this crash who had a passion for helping people in her career and in her personal life. And she finds all of that severely limited because of the injuries that she sustained. So how do we quantify the emotional impact, the psychological toll of all of that in addition to the physical pain that she's suffering? It's difficult to do, but there is a formula. The past pain and suffering formula attempts to quantify the amount of that mental anguish, what the value of that mental anguish has been since the day of the accident. What has Miss Winther already suffered? And at its core, it's based off of the figure of $15 per hour. Now, when you ask us how we arrived at that $15 per hour rate, you have to ask yourself, what would you accept as compensation in exchange for your ability to walk and run freely, your ability to sleep deeply, your ability to work comfortably? Would $15 an hour seem reasonable to you? I think Miss Winther included, as well as any reasonable person in this courtroom would say, that is a very low offer. Nevertheless, it is our baseline. $15 an hour times 24 hours a day, because as I mentioned, Miss Winther does not sleep well at night, and then during the day, she has to deal with the fatigue as well as the discomforts that come along with standing for prolonged hours, bending, lifting, running, walking. So it is a 24-hour a day, 7 days a week that she is in pain, times 759 days that have transpired since July 3rd, 2017 to today, August 1st, 2019. Multiply all of that and you arrive at the figure $273,240 for past pain and suffering. Now, once again, if Miss Winther had been offered this amount in exchange for her mental and physical well-being, in exchange for her physical freedom, for her mental freedom, for her ability to spend time with her loved ones, for her ability to work and help others in her job, she would have said, no, that is a very low number. And then for the second part of the third question, we come to future pain and suffering. Future pain and suffering takes into account Miss Winther's life expectancy, which as I mentioned is 19.8 years. So we start again with the $15 per hour times 19.8 years of life times 365 days per year times 24 hours a day. And we arrive at that conclusion of $2,601,720. This is going to be the last time that Miss Winther can ask for justice for what she's lost. This amount is meant to last her the next 19.8 years of life. It is meant to compensate her for all those moments of anguish, for every minute of radiating pain and tingling and sensation, for all those sleepless nights. This is all that she's going to get. If you were to ask any one of us in this room what amount of money we would take for that kind of loss, it would be much higher than that. We all would turn this down. So, come back to the beginning. Miss Winther survived her encounter with the defendant, but it did not make her stronger. It permanently and severely weakened her. So at what cost did she survive? Thank you.